Thank you very much, Igor. It's a pleasure to see you all again. So many friends. I've seen Susanna, Pia, Norman, you, Igor, Eva, Patrick. I've seen that, I don't know if today, but at least yesterday was also Zoran, Misha, etc. So it's a true pleasure. Let me start by thanking you very much for the extraordinary work done by the organizers, who each year with patience and self-denial dedicate themselves to this event, in particular Professor Vio again and Eva Tutangerkic, and also thanks to all the staff of the Inter-University Center Dubrovnik. So as the chairman anticipated, today's lectures intend to describe the result of one of the researches that have engaged me in the last year, and in a sort of fil rouge with the speech I gave in September 2021, when my investigation was still in its infancy, I like to show the achievements of the research itself. As you know, in the last 2 decades, the maritime transport market is experiencing numerous changes, in particular in relation to the phenomenon of the so-called unmanned vessels, despite the fact that for millennia it has proved to be one of the most conservative sectors of law and commerce, making use of legal institutes that have remained almost unchanged for centuries. We can mention, for example, the bill of lading, the general averages, the charter parties, the limitation of liability, the master and the crew. In particular, the disappearance of the crew on board a ship, and therefore of the human element on board, is profoundly changing the perception acquired up to now of the notion of ship, and can lead to considerable and dangerous uncertainties about the discipline applicable to unmanned vessels. This is perceived so urgently by operators, stakeholders in general, and institutions that numerous projects and working groups have been opened and or set up at national and international level. Just think to name a few of European project Moonin, of IMO's 2018-2023 6-year strategic plan, and of the international working group of the CMI focused on the topic maritime law for mass. Then, on closer inspection, even with the advent of mass, the human factor, despite being significantly reduced, will continue to play a significant role, at least in the eventual remote driving of the units offshore, or even in the programming of the driving systems. Therefore, the liability in case of accidents will not entirely disappear, but the focus will simply be shifted from some subjects to others. So at this stage, we are called to the challenge of identifying the subject toward whom liability for the operation of mass shall be channeled, and to understand what the applicable discipline may be, or rather, whether exploiting the flexibility of the current regulatory framework is sufficient, or whether it is necessary to make changes and updates of the same. In this context, let's say in this exercise, we will see that the institution of the limitation of liability of shipowner will play a central role. This is the reason why the title of my presentation is related mainly to the limitation of liability and of the shipowner and its impacts on the choice of the discipline applicable to the operation of mass. So first of all, we shall evaluate the opportunity of a possible step beyond the current fault-based liability regime. Policymakers, assisted by interpreters of the norms and by the scholars, should take a position on both the nature of the system of liability to be applied to the mass and on the identification of the subject on which to channel the liability. It's not difficult to observe how the uncertainty about the type and the extent of the liability of software and hardware producers and designers can discourage them from entering a new market that is for sure potentially very profitable, but at the same time very risky, considering the extremely high amount of damage that a ship can cause. So, likewise, the uncertainty would reflect on the amount of insurance premiums which would be significantly increased by the insurers in order to rebalance the additional potential risks of compensation. At the time being, except for some expressly provided exceptions, as we all know, the shipowner's liability regime is substantially fault-based. So the affected party must, therefore, prove not only to have suffered damage, but also prove the negligence of the other party. So such a system of liability does not seem to be suitable for unmanned navigation. Indeed, human errors will not disappear, but they will not be made on board, or in any case, not in circumstances of place and time in which they are expected to occur on unmanned ships. So, in the end, accident will not disappear, but the nature of their causes will change. And therefore, also the liability regime should be specularly adjusted. If no changes were made to the current fault-based liability system, there could be a risk of reaching sometimes the undesirable result of giving the shipowner the opportunity to escape liability, thus leaving the victims unprotected. So this, for example, would be the case of an accident due to a loss of the remote connection. Then again, it is pretty clear, as a matter of societal policy, that it would result unfair to unreasonably burden the new risks deriving from the use of the mass on the damaged parties, who would often find themselves deprived of the possibility of being compensated for the loss suffered, rather than on the shipowners, who are the subjects that have benefited directly from the introduction of automation in the maritime transport law market. So an extreme attempt to maintain the application of the fault-based liability regime also for the operations of the mass is to exploit the most this flexibility, changing the angle from which the issue is approached. Maybe deciding to raise the level of the standard of care or to reverse the burden of proof. So the obvious advantage of these two strategies consists in the possibility for the courts to implement them right now, while leaving substantially the current regulatory framework unchanged. Nonetheless, these alternatives are simple, temporary, medium-term solutions. First of all, it is evident that often the shipowner has no choice between multiple alternatives, or rather, he does not have the technical possibilities to examine, test, or evaluate the degree of safety of the automated system, or whether it is bug-free or not. Furthermore, even the best designed artificial intelligence system is not exempt from the risks, obviously. So the progressive heightening of the standard of care that could be required to the shipowner, if taken to extremes, can in fact create a sort of almost strict liability, which would not be introduced through a norm, but would be a consequence of the work of the courts. This is not fully desirable because would cause considerable uncertainty, given the impossibility for the parties involved to know in advance what are the conducts that may lead to liability for damages, and which, on the contrary, would remain in the full discretion of the courts themselves. A second possible strategy is to overturn the burden of proof, so that if the harmful event is a consequence of unknown causes, the risks deriving from the impossibility of identifying the actual cause of the damage, which would exclude the fault of the tortfeasor, would weigh on the tortfeasor and not on the claimant. So even this approach has various limitations. In some cases, it is not possible to allocate the fault on one of the parties that are involved. Then, as a third element to be considered before thinking to strategies that require changes to the discipline currently in force, one must ask whether the various problems presented can be adequately answered simply by applying the principle of vicarious liability. As we all know, according to the so-called respondeat superior, with a Latin word, with a Latin expression, doctrine, the principal is responsible for the negligent acts committed by its employees in the exercise of the activities to which they are assigned, and this regardless of the fact that the employer is in fault. So the application of the principle is much less obvious in my point of view when dealing with failures of artificial intelligence systems. The scope of the application of the rules of the respondeat superior doctrine could hardly be extended to the shipowner who has made use of the work of independent contractors who cannot be considered his employees as servants or agents. So ultimately, even recourse to vicarious liability is not sufficient to eliminate the uncertainties. So which could be the proposal for alternative liability regimes to the ordinary fault-based one? And in this has a strong impact also the mentioned legal institute concerning the limitation liability of the shipowner. So there are many reasons that lead to suggest the introduction of a strict liability regime in the unmanned navigation sector. Some of them are inherent to the consequences deriving from the innate complexity of artificial intelligence systems. Others take into account the importance of the role that human perceptions immersed in its social dimension, the human perception of the mass assumes in directing outcomes of the regulatory processes. So the fact that the mechanism on which strict liability is based allow its activation following the mere occurrence of the event without the need of any assessment of the presence of the negligence of the tortfeasor undoubtedly make it suited for hypotheses of damages caused by a mess. Mess, in fact, is governed by hardware and software instrumentation, in turn made up of an infinity of material and immaterial components. The conception, design, and implementation of them involves an unspecified number of producers, programmers, and designers, and all with their own share of responsibility. So clearly, a strict liability regime considerably facilitates the victims in obtaining the compensation for the damages suffered against the person towards whom the liability is channeled. Then another series of factors that play in favor of extending the scope of the strict liability to mass operations are more, we can say, of an ethical social nature. So the simplification of the compensation procedures for the damages suffered by the victims would, in all probability, make it possible to obtain a sort of public support more quickly, and even the problems arising from ethical dilemmas would be more easily overcome. Then finally, the adoption of a strict liability regime brings with it a deterrent effect on operators, encouraging them to equip themselves with the safest means and tools possible. So anyway, we have to consider that the possible transition to a system of strict liability might not necessarily take place so sharply and without nuances. Just think to a case in which the damage is caused by a criminal act of an hacker who took control of the ship. So in various systems of strict liability, there are examples in which an exemption from the same is provided when the accident was caused by an act or omission of a third party who act intentionally. This is the case of the criminal act of a hacker. So to overcome or at least circumvent the problems set out, a system of a mandatory list of exceptions could be studied. So the draftsman, the legislator, will have to be extremely careful and balanced in the design phase of the regulatory structure, in the awareness that, however strict, the liability should not be strengthened to the point of making the shipowner of an unmanned vessel liable even for accidents that would have been impossible to avoid if the ship had had a crew. So otherwise, there would be a risk of falling into a clear and unjustified inequality of treatment. So which could be, at this stage, the possible choice regarding the identification of the subject on whom to channel the liability? Every time that a strict liability is introduced, as you know, the subject on which it will wait must also be identified at a regulatory level. The main reason is to increase the degree of certainty in the dynamics of the relationship between all the parties involved and prevent the damaged parties from taking action against actors other than the one liable ex lege. So in the case of the mass, where the technology plays a preponderant role, probably the instinctive answer to the question of who is the subject on whom to channel the liability would be the manufacturer. But on closer consideration, this solution would turn out not to be the best, and this for a number of reasons. First of all, the subject that could be included within the qualification of manufacturer are numerous, and yards, software and hardware designers and producers, they all cooperate in various ways and in different phases of the construction process. This is a circumstance that would make it difficult the exercise of apportionment of liability between all of them, unless one opts for joint and several liability. In addition, they should have also insurance for large risks, which they would find on the ordinary insurance market, as it is highly unlikely that the P&I clubs will be willing to offer the insurance cover to subjects other than the ship owners, and moreover to cover damages following accident caused by what we could define as cyber perils. So this would make insurance coverage enormously more difficult to obtain and way much more expensive. Usually, they are not so expensive in general terms in the maritime sector, given the fact that there is a mechanism of spreading the cost of liability on various sectors, thus making them more subject. So perhaps the most suitable figure on which to channel the liability could be the ship owner, both as he is the one who consciously accepts the risk of operating a mass. So this is a logic similar to what is dictated by, for example, the CLC Convention with the Protocol 1992 or HNS 2010 Convention, which provide for a strict liability, as all we know. And so the subject on whom could weigh the liability could be the ship owner, who also benefits from the probable cost reduction and also in consideration of how the maritime insurance market is shaped. So, maritime insurance market finds a solid basis on one of the most iconic institutes of maritime law, that of the limitation liabilities of the ship owner. As we know, there is at uniform international level, the limitation liability is regulated by the LLMC Convention, which ultimately ends up playing a decisive role in making the choice on a regulatory context, on the subject on which to channel strict liability. So to fully understand the relevance that the benefit of the limitation assumes in this context, it is necessary to check which are the categories of subjects who can make use of it, and in particular, if they also include software producers and software or hardware designers. So if we look at the provisions of the LLMC that now I read, especially Article 1, Paragraph 2 and 4, we see that it's clarified that the term ship owner shall mean the owner, charter, manager, and operator of a seagoing ship. And in paragraph 4, it's clarified that if any claims set out in Article 2 are made against any person for whose act, neglect, or default the ship owner or salvage is responsible, such person shall be entitled to avail himself of the limitation liability provided for in this convention. So, from this wording, it seems to be possible to deduce that if the scope of application of convention can reasonably be extended to remote operators, the same cannot be said for manufacturers, software designers, or similar figures, which do not seem to be included even among those subjects for which the ship owner is responsible. So, not being able to make use of the limitation regime, the ship owner of mass and also the subjects, such as software producer, software designer, would experience an even greater difficulty in acquiring an insurance policy. In the face of potentially unlimited liability, in fact, the insurance companies would tend not to issue a cover, or they would do so by asking for extremely high consideration. So this circumstance would constitute an almost unsurmountable barrier for the spread of mass. So these considerations lead to support the hypothesis of the introduction in the unmanned navigation sector of a strict liability regime, with channeling of the same toward the shipowner. This is a solution that seems to respect the dynamics of the maritime transport market without the risk of causing its collapse, and allows to keep intact at least the basis of the economic sustainability of the entire system. So there's another element to be investigated. If there's or not a leeway for product liability in unmanned navigation. So this phenomenon of progressive automation in shipping leads to bringing into play liability regimes such as that of defective products, which have always had a marginal role in the maritime sector. It shall be noted preliminarily that there have never been real doubts about the applicability on principle of the general rules of negligence-based product liability, also in the maritime field, so much so that the yards are liable for the damage caused to their properties by their culpable action or omission, provided that the causal link is proven. So the introduction of new autonomous navigation technologies has, however, made the picture even more complex, adding, on the one hand, additional players to the plethora of manufacturers contributing to the construction and completion of the ship, and on the other, new elements to be taken into account under the various profiles of the applicability or otherwise of the discipline dictated by the so-called Product Liability Directive, that is the number 374 of 1985, which created a strict liability framework. Which are the main differences between the Product Liability Directive discipline concerning the liability and the one provided by the classical fault-based liability system in maritime transport market. But first of all, substantially the Product Liability Directive takes into consideration only the damages to persons and property intended for private use or consumption, and the liability is strict and unlimited. On the other hand, the one provided by the maritime transport discipline concerns also damages to commercial assets. It is in principle fault-based and provides for a limitation of liability. So, in order to verify the applicability or otherwise of the product liability discipline also to the problems related to softwares and hardwares, we should deepen the concepts of product, defect, and producer, which are provided by the Product Liability Directive. I have them with me. So if we look at Article 2 of the Product Liability Directive, we see that the definition of product is For the purpose of this directive, product means all movables with the exception of primary agricultural products and game, even though incorporated into another movable or into an immovable. So it is quite undisputed that a similar conclusion can be reached in relation to a computer hardware. But more doubts, being devoid of a physical consistency, arise about the software. In fact, one must ask whether errors in the formulation of the algorithms or the information inherent in the software are suitable to qualify the software as defective product or not. So, qualifying as a product an intangible asset consisting substantially of alphanumeric information exposes to the risk of creating a precedent by which it is possible to argue that the information itself, whatever its form and content, can be considered a product. Let's see now the concept of defect provided by the PLD, the Product Liability Directive. Article 6, paragraph 1. A product is defective when it does not provide the safety which a person is entitled to expect, taking all circumstances into account. So, bringing the issue in the context of the navigation of mass, it is clear that in the face of such wording, the last word will always be up to the courts, which will have to make a case-by-case assessment. So it is common experience that whenever a software has to operate in an open environment, it is impossible to guarantee that it is 100% safe and bug-free. Third notion to be considered, and again, I read and quote it, the one of the producer. Producer means the manufacturer of a finished product, the producer of any raw material, or the manufacturer of a component part, and any person who, by putting his name, trademark, or other distinguishing features on the product, present himself as its producers. But there's also a second paragraph to this article. Any person who imports into the community a product for sale, hire, leasing, or any form of distribution in the course of his business shall be deemed to be a producer. So in light of this formulation, no interpretative problems arise regarding the possibility or not of including software designers and similar figures in the concept of producer. Obviously, to the extent that the software is actually considered a product. Rather, it can potentially pose a different problem, given the reference is also made to the importer of the product in the community. It's quite possible that the owner of the mass was registered, the latter in a maritime register of an EU member state, can be qualified as a producer, thus assuming a dual status, so he could be subject at the same time to both the liability regime dictated by the directive, so the Product Liability Directive, but also to that provided for by the maritime rules. Generally, in order to avoid the dangerous overlap between regulation relating to different areas of law, the risk of a concurrency of action is solved in practice by giving precedence to the regulation of the maritime field. Now, to conclude, it should be noted that even in the face of a strict liability regime, in order for the producer to be considered liable, it shall be verified the presence of the causal connection between his conduct and the damage. So, the mechanisms and concepts typical of product liability regimes can acquire an increasingly important role in the maritime field so as to offer a wider protection to those who have suffered damage, who can raise a claim against subjects further and different from that of the shipowner. So in the end, which could be the true final conclusion and the proposal relating to the discipline concerning the liability of the shipowner and how to refit or update it. Being aware of the inadequacy of the current regulatory framework, perhaps in this matter, the wisest choice, which reflects a homopoietic approach with a double conservative and at the same time evolutionary nature would seem to be the one to opt for the implementation of a, so to speak, composite two-level liability regime, which would be capable of enhancing the peculiarities of autonomous navigation, but without replacing, but alongside the classic fault-based one. So, in relation only to the activities carried out by the mess, a strict liability of the shipowner could be introduced with a channeling on principle towards the latter, who can then act in recourse against the software designer and producer if it appears that a malfunction of the IT system has contributed to, but was not the only cause of the occurrence of the accident. So the shipowners would thus be strictly liable in all cases in which the damage was caused to commercial assets, as well as in those cases in which the damage, whatever its nature, was not determined solely by a software defect, or even residually, when it is not possible to identify the cause of the damage with reasonable certainty. So the same, let's say, legge ferenda could then provide for the application of the discipline dictated by the Product Liability Directive, making an express reference to it, with the consequent strict and unlimited liability of the producer and its channeling on the same in the event of damage from death or personal injury, and if the accident was caused solely by a defect in the software itself. So in this way, an overlap between regulations relating to different areas of law would be avoided. De facto also respecting the practice of giving precedence to rules of maritime origin. So the norm making a reference to the Product Liability Directive, in fact, would be attributable to their category. So this is more or less my proposal. I think I have already bored you too much. So if you have some questions, I'm here for you.